Hello and welcome to our discussion today on influencing legislation. I'm Sara Catley. I'm Director for In-House Editorial for Thomson Reuters Legal UK and Ireland, and I'd like to introduce Daniel Greenberg. Daniel is the General Editor of Annotated Statutes and Insight Encyclopedia for Westlaw UK and Counsel for Domestic Legislation in the House of Commons. Daniel, welcome. Thank you for joining us. So, Daniel, tell me, why do organisations seek to influence legislation?
Well, there are two main reasons. The first is simply the pace and volume of legislative change that companies are having to deal with in compliance context and in wider context is just bigger than it's ever been before. Primary legislation, devolved primary legislation, secondary legislation, quasi-legislation, procedures, guidance, directives, the pace and the volume are so enormous that if you're simply reactive, you're being buffeted around by constant change and sometimes with very significant compliance implications and sometimes with competitive implications. You have to take some sort of proactive approach to anticipate what's coming in order to be able to influence the compliance agenda, in order to be able to make sure that you are not simply being a reactive cork being tossed around on the sea of legislative change, but you're doing what you can to deliver for your business and ultimately your customers an appropriate degree of control of change insofar as you can. And we'll come back later to how much you can, which is also much more than you used to be able to. But the other main reason is simply because everybody else is doing it. If you are the one company in a particular field that is allowing everybody else to express their needs really effectively, and you don't, that can actually be a significant compliance disadvantage, a competitive disadvantage. So it's because there's more legislation around, it's changing faster so you can influence it, there's something to influence all the time, and it is something that people are doing, and therefore it's something that you, a particular business, you ignore it at your peril.
If we're going to go ahead and try and influence legislation, I guess we need a better understanding of how law is being made now, and you mentioned that it's being made in a different way to the way it's been made in the past. Tell me a bit more about the legislation making process today.
Yeah, I mean, I think the most obviously relevant difference in the context of talking about influencing legislation, the most obviously relevant difference is that it is a more collaborative process. 30, 40 years ago, acts and statutory instruments were prepared behind the doors in Whitehall, in Westminster, and then exposed to the public and take it or leave it. Well, you have to take it. Now, for various reasons, government wants to appear to collaborate, and sometimes they do want to collaborate. They always want to go through the consultation motions, and some consultation is more real than others. Some consultation is really just a mini referendum, so they can stand up and say 60% of businesses support what we're doing. Some consultation is genuinely about getting policy input from the stakeholders. So the big difference now is that there is an observable, transparent process that is available to be influenced, which there wasn't 30, 40 years ago. The other main changes that will be of interest in the context of this discussion are this. Much more is being done now at secondary subordinate legislation level. We have huge numbers of very, very big acts. They are increasingly what we call skeleton acts. They're just a series of powers. Minister can do this, minister can do this, minister can do that. And all the meat is put, all the flesh is put on the bones of the skeleton at the point of the subordinate legislation. Again, that's a significant, it's a trend that goes back decades, but the pace has been accelerating, and subordinate legislation in terms of volume compared to the volume of primary legislation, so long as you look at pages and not at numbers, you can see vast exponential growth. So much more is being done at that level, which is, of course, traditionally easier to influence because it's not simply a parliamentary process, but it's also trickier to influence because instead of having 6 public stages with a number of amendable stages. It is all being done behind the scenes, and you have to take advantage carefully and appropriately of all the times in which the actors come in front of the stage and say, do you want to influence it? This is now your chance. The next major change is the growth in the use of quasi-legislation. Again, as I say, it's directions, it's guidance, it's procedures. If you do a little search, if you go and do a Westlaw search for the word guidance in primary legislation before the year 2000, you will find a few, but you're not going to find many. Do a search for post-2000 and you find hundreds and hundreds and hundreds. Pretty much you find in a big act with a few hundred sections, there'll be a few hundred powers to give guidance. And each set of guidance is separate. There are big accessibility of access to the law issues about that, but that's not the focus of our discussion today. But it is very important in terms of influencing, because that is where the final compliance impact of the law rests. You know, clients don't care very much, to be honest, about the big political stuff, mostly at the primary legislation level. Most of the statements that grant the powers to make subordinate legislation will be pretty harmless. You know, the minister can go off and do something about making sure that competition law works. Well, you know, 3 cheers for that. Then I look at the secondary legislation. Now I see the minister's ideas on what he or she thinks that actually means for business. I'm beginning to get a bit more interested. But when I finally see the enforcement guidance, what the FCA is being told it must or mustn't do, what the FCA is telling other people they must or mustn't do, that is actually the crunch, the day-to-day crunch in compliance terms. And that's changed dramatically. The courts are trying to be a little bit careful in refusing to allow departments to use guidance and directions as a second bite of the cherry. This is what we wish we'd enacted. The courts aren't trying to hold that back, but what they can't do is prevent Parliament from granting powers to effectively put all the compliance flesh on the skeleton at the quasi-legislation stage. So those, I think, are the 2 things that have changed dramatically. Much more is being done by secondary legislation, and much more is being done by quasi-legislation. I mean, just to give our viewers a little taste, a feel for the numbers we're talking about, you're dealing with roughly 100 new acts a year if you look at Westminster and the devolved legislatures. And then you're looking at about 4,000 to 5,000 new pieces of subordinate legislation, new statutory instruments a year. And quite a lot of those are very trivial, but you know, it's a large amount. And as I say, the page rate is of the ones that matter is increasing all the time. In terms of quasi-legislation, I estimate, and it has to be an estimate because, as I say, access to legislation, serious problems around quasi-legislation, but I estimate we're talking about 40 to 50,000 pieces a year. It really is extraordinary. But you just count up the number of times directions, guidance are referred to, and sometimes they'll be consolidated into a single document. But in terms of compliance, in terms of legal structure, I have to look at each one separately. Enormous amount there. And that's the big change to the way legislation is produced. The only other thing I would say, in terms of the changes of how the process works, I think Parliament has also opened up a bit. Mm-hmm. Parliamentarians expect and value briefing in a more interactive way than they once did. They always wanted, if they were going to stand up a second reading speech on a planning bill, they always wanted the planning industry to send them some nice, neat notes so they didn't have to write the speech themselves. That was always true. But now they're looking for example, amendments to table. They expect to be supported by the trade bodies, the industry bodies, by the stakeholder bodies generally. They are open to being supported in a much more interactive way than they once were, which again is a challenge, but it's a massive opportunity. Mm.
I think you've written in the past on the risks that we face following Brexit of kind of a bit of a policy-making vacuum.
Yeah.
And I wondered if you wanted to comment on that in that context. It seems almost as if there's an expectation that businesses will fill a bit of that.
Yeah, well, I mean, someone's got to, and that's absolutely right. I mean, this is true for Westminster and Whitehall. It's also very true for the devolved assemblies and the devolved legislatures and governments. There are whole areas in which we have not made policy for the last 40 plus years. And I mean, people talk a lot about we're going to need hard negotiators. Well, I dare say we will, but you know, that actually is a skill that's relatively easy to find. Policy making is quite difficult to create capacity for policy making, and the civil service builds it up over time, and you can destroy it very, very quickly. Mm-hmm. And it is going to be very difficult. We're just not used to thinking about policy impacts in agriculture, in a lot of health and safety environments, in a lot of areas that originally one would not have associated with what was the common market originally, but are now absolutely as part of the level playing field. Employment law policy, health and safety policy, consumer protection policy, areas that we would not have expected. We have no policy-making capacity because we haven't needed it. Oddly enough, we do have negotiating capacity in those areas because we have wanted to feed in as the directives and the draft directives were being developed. But suddenly there's nothing to feed into for us. We're going to have to decide what are we going to do with these vast areas of regulation. The public want to see them deregulated. That's what Brexit is about. Clearly we can't throw it all away, partly because there'll be a need for consistency and compliance with the EU area, whether as part of our deal or simply to enable people to trade in a fluid way. So there will be some of that we'll have to keep, but a lot of the rest of it we'll have to keep because it's a good idea. Environmental protection. To the extent that we're not required to follow the environmental impact assessment process, for example, we still don't want to suddenly open season on badgers. That's not going to happen, right? People are still going to want to see ecological and environmental concerns reflected in legislation. So who is going to make the policy? Well, you're absolutely right. They will look to the industries, they will look to NGO sector, they'll look to the third sector, but they will look to industries to come forward. And I think what will be I think your question is a very good one, if I may say so, because what they will be looking for is something that isn't just self-serving lobbying. They'll need to protect themselves against that. They will be looking to industry sectors who are able to say, look, obviously we're not going to go against our interests, but we can help you to come up with something which will help us because it's a coherent and sensible legislative environment, but we can do it in a balanced way. And we'll talk to you about the different sectors that are involved, the different interests that are involved. And I think if industry is able to speak in a very reasonable way, it will come as gold dust to Whitehall, who will be looking around saying, right, I've got to produce a white paper on replacing the consumer protection in package holidays provisions, what we do need to have and what we don't need to have. Anybody got any ideas? And ideas will be welcome. So
I think it sounds as if there's a lot of white space for organisations to aim at. There are a lot of opportunities at different points of the process for them to get involved in influencing the outcomes. Let's have a think about kind of what the most effective strategies might be for a business and at what key points they might try to get involved in the process.
The most important thing to remember about legislative lobbying is that the traditional points at which industry, commercial interests lobby are all too late. For example, people make a huge amount about pre-legislative scrutiny now on bills. And you've got a draft bill in front of you. You cannot turn a giraffe into a hippopotamus just by tweaking an ear here and a tail there. You need to get into its guts. But it's now you've got the skeleton, you've got the structure, and government does not enjoy, whether we're talking about local, central, devolved government, they don't enjoy completely taking apart and redoing something that they've spent months building. So the main message is to come long before you've got draft legislation. That's much, much, much too late for your opening contact in attempting to influence. Much too late. And really, the point you're aiming for is the point at which a gleam starts showing in a minister's eye that he or she thinks we might do something about X. Well, who puts gleams in ministers' eyes? It's civil servants. And this is back to a point which you and I have shared on a number of occasions, the importance of having friends in low places. Businesses are very good at remembering to invite the trade minister to their annual cocktail party. Well, it's not a lot of use, partly because he or she won't be there for very long, as I'm sure a lot of our viewers recognise this. You spend a lot of time building up an effective relationship and then they're in the Foreign Office or sacked the next week. And civil servants last longer. But actually, more importantly, ministers influence and call high-level political policy. The vast amount of details that matter to business are low-level policy that never get onto the ministerial radar. They're never part of a briefing to the minister. They are dealt with by your friends in low places. So I always tell people, if you go into a meeting with the minister and he or she will be surrounded by a little group of civil servants, and this is true in the devolved administrations as well, if there's a single one of those civil servants that you haven't already had a conversation with, it may be that you're going to blow the whole meeting because you'll convince the minister and you'll go out and she or he will say to you, yeah, no, that was really good, I'm with you, we'll deliver. And you'll go out and the minister will turn to his or her civil servants and say, what do you think about that? And one of them will pipe up and say, well, you can't do that because of this. And the minister, oh, well, shame, because I'd have liked to help them, but all right. And civil servants still, the yes minister hasn't gone away. Civil servants, of course, control policy because details do dictate policy. It may be a wonderful high-level political idea, but if it can't be done for some very specific, low-level, trivial, detailed reasons, then it can't be done at all. However, if you have squared those, if you've worked with those people, if you've supported them in their policy development and they regard you as helpful partners, then if the minister's a bit dodgy and she or he turns to the civil servants with you in the room or without you in the room and says, well, what do you reckon? Then you say, oh yeah, no, we want to, these people know what they're talking about and they are helpful to us long term and we can deliver for them and we trust them. And trust is terribly important because lobbying, now we've got lobbying registers, right? We've sort of gone into the American system of we acknowledge lobbyists and we don't trust them an inch. But real lobbying is about developing a partnership of trust with government. And it can be done. It can be done because there is confluence of interest. The idea, and again, when I left the public sector and joined the private sector, I had this myth that I brought with me that what lawyers do in the city is help people circumvent laws. And I had this sudden awakening. That's not what goes on at all. Because actually business finds it's cheaper, easier and simpler to keep the law. And they want to keep the law. It's often difficult to find out what the law is, what the law means, what it requires of you. And the purpose of construction is all very well and good. But if you can't find out the purpose, again, that's another discussion for another day. But there is a genuine partnership between the stakeholders are going to be affected by the law and the people who are making it. And as I said earlier on, government is more receptive to that than it ever was. So I think the point at which you start to influence legislation is before there's any legislation, by building effective relationships with the team who operate in the policy area that affects you. And then, when a piece of legislative policy comes up because the department wants to make a change or because you want to make a change, and again, like I said before, we should be more proactive now. There are loads of things where people go around saying to themselves, it's ridiculous that we have to do this, this and this. It adds X% to our costs and it doesn't serve any legislative purpose, but because it says in that SI, so we're stuck with it. But you're not stuck with it, because SIs can be changed very, very easily. And one of the advantages of the bulk of legislation having been pushed down this pyramid to quasi-legislation and subordinate legislation, acts are difficult to change. Subordinate legislation is relatively easy to change. Quasi-legislation is incredibly easy to change. It's done on the back of an envelope, so you just find another envelope and you start again. So it really, this is about coming forward, and I've done this where we had a big planning project which eventually was done through a development consent order, and originally the department said, well, you can't do that because it isn't within the class that a development consent order is available for. And I said to the client, well, why don't we change the law? So they asked the department, and the department said, oh, well, we can't do that, it'd be very difficult. So they came back and said the department said it would be very difficult. And we said, no, it wouldn't. This is how you do it. Here's what it would look like. Here's a timeline. Let's tell them to do it. And they did it. And we were able to do the whole project through a development consent order rather than a private bill, with enormous advantages of timing, of cost, of predictability, of political risk minimisation, everything. So the first, I know it's a slight digression from your question, but the point is that the trigger is not only legislative change being announced by Whitehall, it can sometimes be that we spot there's a legislative change, there's no reason why ministers or officials should oppose it, let's go ahead and do it. So as soon as you spot that, you need to start to feed in before the bones on this animal start to become concrete. And one of the ways to do this is to articulate for yourself what the key objectives are, what do we want to achieve, and more importantly, normally, what do we want to avoid? Because it's the unintended consequences of legislation that are the normal preoccupation of stakeholders. Generally speaking, they either support the main policy or it's big political policy, there's nothing we can do about it. So we accept it, we're going to have to live with it. But it's looking for the anomalies, it's looking for the unintended, the things that are going to cost us money day on day and going to impact on our customers, possibly in an unhelpful way, that ministers don't see, that officials don't see. So you have your wish list of what you want to achieve, and you have your wish list of what we want to avoid. And ministers are open to being given clear briefing of heffalump traps they're about to fall into, because they don't want 2 years later to have the select committee turning around to them and saying, oh, you know, you may have achieved this objective, but look at this unintended consequence, look at the misery and cost that you've caused. How much does this cost British business? They really don't want that. So your input at that stage is very tightly focused. This is what it would do. This is why it would be a bad idea. This is what we need to avoid. These are the costs of that unintended consequence, and impact assessments should be costed out in a clear, actuarially defensible way. These are the potential costs. There will have to be an impact assessment these days for every piece of legislation, so you provide some input for that. And this is how you can achieve your main policy objective without falling into that particular heffalump trap. Tightly focused, short, a clear win for you, something that if you're a trade organisation or an industry representative organisation, you can then go to your members and say, look, we achieved this for you. If you're a direct lobbying firm or direct lobbying industry, again, a win that you can show to your colleagues and you can show to your board in particular, it was worth being involved in the legislative process because this is what was going to happen, this is what we've avoided.
So we've begun our process, we've made our friends in low places. Let's move a little bit further into the process and talk a little bit about working with select committees, because I think that there are some unique challenges around that as well.
Yeah. Again, it's about when you interact, in part. There are subject-based select committees for all areas and all departments now, and have been for decades. So you can make good contact with a select committee before a legislative proposal has come along and say, wouldn't you like to have a little inquiry into this area of law? Select committees are always looking around, what's our next inquiry to be? And they do some big inquiries, but they do little inquiries as well in parallel. And they enjoy being approached with sensible suggestions of focused inquiries that they can mount. So in terms of trying to get the initiative, get momentum behind a potential legislative change, or discussions of a rumblings of a prospective legislative change, yeah, engagement with the departmental select committee is good. In the devolved assemblies and parliaments, there's a particular advantage because the subject, the substantive select committees also scrutinise the legislation when it comes to them. So you build up a continuity of interest and a continuity of discussion with you and the members. So it's very good. So that's point number one. Point number two, pre-legislative scrutiny. Okay, as I say, it is too late in some ways because the bill is already part ossified, but the government wants to be seen to react at pre-legislative scrutiny. In committee on a bill, they are normally very, very defensive. Pre-legislative scrutiny, they generally want to show that they are open to improvements. So yes, you have to get in there, you have to make sure that your written evidence on pre-legislative scrutiny is tight, short and clear. The longer the worse on the whole. And you have to position yourself so that you are likely to be a natural oral witness. Someone will be invited to come along and give oral evidence, which can have a very significant impact on the way the draft bill is reshaped before it's introduced into Parliament. And you do the work in parallel with your contacts with our friends in low places, so they don't feel this is about you shooting at their work and trying to destroy it, but they feel that so far as you can, you're being very open with them and you're helping them to make it a better piece of work. Then, let's look at parliamentary committees generally. The one that, on the whole, is not well used, I mean, select committees are underused, they're not badly used, but the one that is not well used is the Public Bill Committee. And every bill, almost every bill, goes into Public Bill Committee, and there's an evidence-taking session on most bills now. That was introduced when the Public Bill Committees took over from what used to be standing committees on bills. And I see loads of people, they put in a written submission at some point and think, excellent, we've done a bit of lobbying. But a written submission will go straight in the bin if there's nothing to back it up. It goes to the members of the committee, they might have a flick through, but again, it's their researchers and support staff who will have a flick through. Have you made contact with, if you know which MP or which peer in the Lords might be interested in picking up your points and pushing for them, whether it's a positive thing or something you're trying to avoid, have you made contact with their office, with their support staff, with their researchers? Have you said, we're going to send you the written submission, here is something we think that your member or your peer will find of interest in their, it may be a constituency interest, it may be that they're on an all-party parliamentary group on the subject, it may be they're a member of the select committee, it may be they're going to be a member of the Public Bill Committee. There are all sorts of reasons why someone may have an interest that you can support by helpful briefing. Just sending in written submissions to the Public Bill Committee, you may as well save yourself the bother. You want to be invited to give oral evidence where you've got something big enough to say, and again, you want to pick your bills carefully and say, this one, okay, not a lot to say, bit of written briefing, make sure it gets onto the desks of this person, this person. And if you are going to do written briefing and you're trying to get a change, you're saying this is okay, but it needs to be twiddled like this, or this is not okay, but it wouldn't be so bad if it were twiddled like this, give them a draft amendment. You give them a draft amendment, And a backbench member, the opposition, they'll take it and they'll put it down. You're giving them something to do. You're telling them what you want from them. And too often, lobbying is done as a sort of vague, moany whinge without telling the person you're talking to how they can help you. And drafting an amendment for them to put down is the obvious way. This is what, and they love that, because that's what they're there for. They want to be tabling amendments. They want to be seen to be effective in committee. Well, they're not going to write the amendments themselves. You'd write it, they put it down. Effective partnership again. And keeping the civil servants in the loop so they don't feel you're going behind them and now, as I say, trying to shoot at what they're doing. Working with everybody to make a better bill, to make a better instrument, whatever it is.
Well, it's a very intensive process, I think, if you really want to be truly effective in influencing legislation, is what I'm taking away. And I'm wondering whether there's scope for that, given the huge volume of consultation that the government seems to have appetite for. How do I prioritise?
Yeah, no, that's absolutely right. And businesses are completely overwhelmed with the amount of consultation, the number of consultation documents coming in from, again, central government, local government, devolved governments, and they're looking at Europe as well. And we'll have to carry on looking at Europe, Brexit or no Brexit. They'll be looking at all of those. So yes, it is absolutely overwhelming. It's tens of bits of paper a week for some industries. Others aren't so overwhelmed. The first thing is there is no civic duty to respond to every single consultation that might conceivably be relevant to you. And even if there is a civic duty, there's certainly no law requiring it. So I think the first requirement is a sort of hefty dustbin to go through. Again, if it's something where my interest is marginal, the big players are going to be majoring on this and they're going in the same direction as me. My interests are their interests. Leave it to them. Why am I wasting my time writing something that 1,000 other people are going to write and 1,000 other lobbying machines are going to get to work on? In some cases, they're going to be more effective than me because they care more than me. So if it's irrelevant to me, it goes in the bin. If it's relevant to me, but I've got nothing to add to what I know everybody else is going to do, it goes in the bin. If it's relevant to me and I do have an interest, but the trade bodies, the industry bodies, they're on the case and I trust them to be on the case, all I need to do is to say to them, what do they need from me? And it may be that they need me to top and tail their briefing and send it in with multiple. I'm not a great fan of multiple mail shots on consultations because departments filter them out. And pretty much 50,000 responses from individuals all saying exactly the same thing, clearly orchestrated by a particular organisation, count as one response. So effectively. So big bin is number one. Number two, okay, I've identified a certain consultation, I do have something to add. How am I going to structure my consultation response? Again, governments, officials, ministers do not enjoy being told that they're just barking completely up the wrong tree, and on the whole, consultation responses that are simply negative, even if they're really well argued and well supported by evidence, it's a bit too late because the government pretty much has decided, mostly, this is what I'm going to do, and I'm consulting on how. We used to have green papers and white papers. There really aren't. The distinction is not there anymore. We very rarely consult when our minds are so open that the response, this is just a really bad idea, will mean that it goes away. Sometimes, but not often. So the key is to make sure that our response is positive but nuanced. So either we support the main idea or we are genuinely resigned to it. We accept you're going to do it, we'll support that, we'll cooperate, we're preparing to comply. Now help us to comply and help us to help you from falling into the following heffalump traps, and then we've spoken about that, how you demonstrate, here's an unintended consequence, this is how you avoid it. So it's about being seen to be a positive partner in the development of the legislation rather than just sniping from the side. And I think, I mean, it sounds so obvious when we say it, but you look at a lot of consultation responses and they are just plaintive attempts to put the clock back, which is a waste of paper.
Thank you. Well, I think that's given us a huge amount to think about. Thank you so much for joining us today, Daniel. Certainly I'm going to be taking away a better understanding of how complex the legislative environment is, but how many opportunities that presents for us to influence the legislation that really matters. And I will definitely be breathing a sigh of relief about putting my very big waste paper bin or recycling bin into use for the ones that don't really matter. But thank you again.
Thank you.